I will try to, I will address a couple of issues pertaining to the issues of the enforcement under the recast regulation, in order to see to what extent the changes may have a chance to repair, so to speak, and to fix problems that had been encountered in application of the Brussels IIs. Speaking about the problems, I just would like also to draw your attention to the results of the project, the research project, which was supported by the European Commission and carried out by the Asser Institute with a number of our colleagues and partners in this project, in which also the results contain not only the guide for application and recommendations, but also the problems encountered in the application of the Brussels II-bis regulation in the member states. So on the same website, we can, it is also possible to see national reports from all member states that point out to the problems encountered by the national courts in applying the regulation. We also, the project started just a couple of months before the Commission has published the proposal, so we also had an opportunity to reflect on the proposal. I wouldn't say that I listed here all most important changes. I just listed few of the changes in the recast. Only few I will address here, as I mentioned, and only those relating to the aspects of the enforcement and recognition and enforcement. In particular, the question of the abolishing of exequatur, the fact that the regulation harmonizes partly the rules, certain rules on the enforcement, whereas questions that are not harmonized by the regulation, the courts will have to rely on their own national rules on the enforcement. So, as I mentioned, the main two issues that I would be discussing is the abolishing of exequatur and adjusted rules on the enforcement of decision in EU child abduction cases. So the exequatur is abolished in a way, in a manner similar that has been done under the regulation Brussels I bis. There is basically no need to obtain the declaration of enforceability, and in the same way under the Brussels I regulation, a party that believes that there are grounds for which the enforcement should not be granted, in particular, of course, speaking about the parental responsibility, that party can start separate proceedings in which those grounds for refusal may be raised. What is also similar with respect to Brussels I is that basically all grounds on which the recognition and basically enforcement can be refused are retained under the regulation. I'm really glad also that the ground that the child has not been given an opportunity to express his or her own views has also been retained under the regulation. As we all know, in the Commission proposal, it was omitted. And also it was obvious also within our research group that we had different views on how to interpret the lack and omission of that ground. And immediately one of the suggestion was, well, it is not needed because it can be also reflected or relied upon within the public policy exception. And I see that as exactly one of the potential problems if that had not been returned amongst the grounds. First, because there will be opportunity of a discrepancy in the interpretation of public policy, and also discrepancy amongst the member states in the application of that provision. So, as I said, I think it is improvement that has been back in amongst the grounds. Of course, I think also that it is improvement that it is somewhat clearly defined. So, and that not always the fact that child has not been given opportunity to be heard is not an automatic automatically a reason to refuse enforcement, but there are exceptions, and I think that this is also appropriate, especially the cases where the hearing of the child and would not be relevant, such as the issues involving the property. And also exceptional circumstances are one of the exceptions from that rule. So all other, as I mentioned, all other grounds have been retained. Here also, immediately, I would like to, even though I would come back to the point of Article 56, paragraph 6 later on, but here we also see the possibility of expanding basically the reasons for the refusal of the enforcement. Regarding the structure of the regulation, it seems that I would say that the structure, especially of the rules and the enforcement, is improved. However, especially the fact that there are numerous rules, I am not really sure that it would lead into the ease for the courts and easy application of the regulation. Further, I would continue with the certain changes in the regulation which are connected with the enforcement proceedings, and these are amongst the definitions. So we also see that we have now a definition of the provisional measures, decisions on the provisional measures, which are considered as decisions to be enforced under the regulation. Here again, we have a reflection of that rule in a similar manner as under the Brussels I regulation. So in that sense, a definition of the provisional measure only if it is granted by the court which had jurisdiction in the and on the substance of the matter. And also, I think it is positive that also the status of the decisions rendered under the Hague Convention are also now expressly included amongst the decisions. And the same goes also for the provisional measures taken by the courts when ordering a return of the child. So that these measures, and I think also that this is an improvement, that those measures will be enforceable in all other member states until the court having the jurisdiction in the custody over the custody of the child would replace that decision on the provisional measures. I would, in general, consider, I see that as a positive step, that there is a certain consistency in regulating a certain issue in a similar manner in different instruments. So I see that also as an improvement, that that approach in the recast Brussels II bis regulation does follow to a certain extent also approaches taken, for example, in Brussels I bis regulation. On the other hand, I would also say that we should not always the parallels are appropriate. It is not always appropriate to follow the same approach from one legal instrument into another. Here, I would just briefly refer to, for example, revising on the rule of lis pendens in Brussels II bis recast regulation. I really don't see that as an improvement, and I also don't see what is the ratio behind that decision, considering that prorogation clauses under the Brussels I regulation are not comparable with prorogation of jurisdiction under Brussels II bis. So this is just to illustrate that it is very, very positive to have a certain degree of consistency in regulating, but I don't think that they are always appropriate. With respect to the last point, which I would like to address today, is changes on the rules concerning child abduction. And most importantly, I would concentrate on the changes that affect, of course, the enforcement proceedings. One important aspect, which is also let's see. So I've been dealing with the definitions already. Before I was just, I forgot to move with the slides. So before I turn into the question of the child abduction, I just also would like to remain within the issue of the consistency among legal instruments of the European Union. What we see here is that there is significant discrepancy in the approach, for example, when unifying the rules on the enforcement of judgments in various European Union legal instruments and private international law. We have seen, for example, in the field of family law, we see different regimes of enforcement. We have abolishment of exequatur on one hand, within the Brussels IIter regulation recast, but we have different systems of how that abolishment. We have abolishment of exequatur for the privileged decision and ordinary, so to speak, decision. On the other hand, exequatur is also abolished in certain other instruments like maintenance regulation, but again, grounds are different in the maintenance regulation from the one in the Brussels IIbis regulation. So, and more importantly, there are also certain instruments which are closely related to the Brussels IIbis recast, which still require exequatur. So we know that matrimonial property regulation, there is still requirement of exequatur. So in that sense, it is very, very difficult, I think, for the judges and generally for practice to grasp all those different approaches in, for example, unifying the rules on the enforcement. We have seen the same trend also in the field of commercial matters. Also, we have in the Brussels IIbis, there is also abolishment of the exequatur with very different reasons from the abolishment of exequatur in another, for example, in the enforcement regulation, in the small claims regulation, they follow a different approach. So this is something that I would say, well, can be difficult for judges to understand different methods of the enforcement. So now I would like to get to the last point which I wanted to address today, and this is the changes of the rules on concerning the child abduction. So the first, I would say, first very, very important change is the change on the jurisdiction part, stating basically that only the decision taken by the court having jurisdiction on the custody will be enforceable as a privileged decision. So I think it is really, really important improvement. In my view, I would fully agree with Ilaria that it would have been much, much better if overriding mechanism would not have been the part of the Brussels IIbis recast. Since it is retained, so let us see how it can operate and whether the problems really encountered in practice will be repaired by the changes in the regulation. So since we still have overriding mechanism, I think it is important improvement that this has been clearly stated now, that this is not any court in the country of origin, so in the country of the former habitual residence of the child, but this is exactly the court that has jurisdiction over the custody. So in that sense, it is improvement of the practice which existed before, and in particular the point raised in Posse judgment is hereby overruled. Another important, I would say, improvement is, again, another point with respect to which the rule in Posse judgment is overruled, and that is the reason to refuse the enforcement and recognition, to refuse the enforcement of return orders taken in the country of origin. That was under Article 47. which is under the current Brussels II bis regulation. The European Court of Justice in POV's case had to interpret this rule as well. The court held there that these are the irreconcilable decision, but that is in the country of origin. So that is in the country where the decision had been taken. Now we see in Article 40 departure from this rule. So we still have an irreconcilable decision as the sole ground to refuse recognition, to refuse enforcement of such decisions. But this is now clearly stated that this is a decision irreconcilable with a later decision concerning the same child in the member state where recognition or enforcement is sought. So this is again, or irreconcilable with the later decision taken in another member state or a non-member state, which can be enforced in the country of the enforcement. So we see here that this is again an important departure from the rule and interpretation of Article 47, paragraph 2 by the European Court of Justice in the case POVs. And finally, the third most important, I would say, departure again from the rule in POVs is the possibility to suspend enforcement under Article 56, paragraph 4 of the regulation. So that would be possible if the child by the enforcement would be exposed to a grave risk of physical or psychological harm due to temporary impediments which have arisen after the decision has been given or which are caused by a significant change of circumstances. So under Article paragraph 6 of that provision, we see that the refusal, or it can be the reason to refuse the enforcement if the risk is of a lasting nature. So this is now the reason, basically, for which the recognition or enforcement may be refused. This is also, there is no doubt that it includes privileged decision, because there is a specific reference to in paragraph 2 to Article 50 of the regulation. So in that sense, I would say, so these are a number of conclusions. As I already mentioned, the structure, it seems to be a little bit more appropriate and easy, but again, I doubt, it is not certain whether the improvement, whether that would mean an improvement in practice. It is pity again that overriding mechanism has been retained in the regulation, but there are provisions which are, I would say, to mitigate the damage. So in these 3 points, which I think are the most important, and in particular in those overruling the conclusions in the European Court of Justice in the case POVs. I also, as I mentioned, there is maybe we can say a generally positive trend to align certain provisions with other European Union instruments, but then again, it has to be done really with due care, so to speak, and not to follow the same approach when the approach is not entirely appropriate and when the provisions are not comparable, as I mentioned, for the prorogation clauses. As I already mentioned, major drawback of the unification I would see on the European Union level is that there are different systems of the enforcement mechanism maintained in different instruments, and in particularly in the very closely related instruments, which may hinder the uniform interpretation and application by national courts. Hereby I would like to conclude, and thank you very much.